Guyana's case against Venezuela before the International Court of Justice, the world's highest international judicial tribunal, concluded this afternoon. Both Guyana and Venezuela presented their arguments in 2 rounds of oral pleadings between May the 4th and May 11th. The court will now deliberate on the matters before it and in the coming months issue its final judgment on the merits of the case, which will be legally binding on both parties. The very fact that the case reached the ICJ and that the written and oral phases of the proceedings were carried out to their completion represent a triumph for the rule of law and the rules-based international order. Dispute between states must be resolved peacefully, finally, and in conformity with international law. They must not be allowed to fester indefinitely. They must never be resolved by threat or use of military force. Guyana has pledged repeatedly, including at these hearings, that it will abide by the court's judgment, whatever it may be. Guyana is confident. In fact, after these oral hearings, Guyana is more confident than ever that the court will uphold the legal validity of the unanimous arbitral award of 3rd October 1899 that established the international boundary between then British Guyana and Venezuela, and will confirm that it is the final, definitive, and permanent lawful boundary between Guyana and Venezuela. Guyana is very proud of the presentations it made in these hearings on Monday, May 4th and Friday, May 8th. It believes that its arguments were compelling and convincing, and that they showed the lack of merit in Venezuela's arguments, both on the facts and on the law. Guyana is grateful to its representatives in these proceedings, whom I have had the privilege of leading, including the Honorable Hugh Talbot, Minister of Foreign Affairs and International Cooperation, and Mr. Carl Greenwich, our agent. Guyana commends and extends its deepest gratitude to its all-star international legal team, headed by Paul Reichler of the United States, Professor Philippe Sands of the United Kingdom, and Professor Alain Pelé of France, among other distinguished advocates. The court's final judgment will bring to an end the controversy that arose in 1962 when Venezuela for the first time challenged the lawfulness of the 1899 arbitral award and the international boundary it established after accepting, respecting, and complying with the award and the boundary without protest for 63 years. The oral hearing established that Venezuela made this very belated protest precisely at the time when Guyana was nearing its independence. British troops would be departing, and Venezuela would have a significant military advantage with which to press its antiquated claim to nearly 3/4 of Guyana's territory. The very claim that the tribunal of 5 preeminent arbitrators rejected in 1899. Before departing Guyana in 1966, the British negotiated an agreement with Venezuela to assure that its challenge to the validity of the 1899 arbitral award would be resolved peacefully. The Geneva Agreement of 1966, to which Guyana became a party upon its independence that year, provided first for a 4-year period of bilateral negotiations to resolve this dispute. These negotiations were unsuccessful. In the circumstances, the Geneva Agreement provided first that the Secretary General of the United Nations would choose the proper means of the final settlement of the controversy, with the power to choose new means if the prior means that he selected failed to achieve such a settlement. After more than 50 years passed without a settlement, Secretary General Antonio Guterres decided in January 2018 that the controversy should be settled by the International Court of Justice. His decision was binding on the two parties. Guyana then initiated the proceedings at the ICJ in March 2018. Venezuela responded by challenging the court's jurisdiction. After receiving the arguments of the two parties, the court issued a judgment in December 2020 in which it ruled that it had jurisdiction to determine the legal validity of the 1899 arbitral award as well as the international boundary between Guyana and Venezuela. The case then proceeded to the merits phase, which included the presentations of written briefs and ultimately the oral hearings, which concluded today. We will await the court's final judgment on the merits with patience, decorum, dignity, and optimism. We will continue to address Venezuela in a spirit of peace, cooperation, and friendship, and as sovereign equals. We will respect Venezuela's sovereignty, as we have always done, and insist that Venezuela refrain from trespassing on or threatening Guyana's sovereignty. We have heard statements of Venezuela's representatives at these hearings, including today, that they do not accept the ICJ jurisdiction and will not abide by its ruling. This would be a breach of its most solemn obligations on the United Nations Charter and the Charter of Organization of American States and general international law. It will not be allowed by the international community of states to defy the most fundamental rules of international law, which demand a world order based on the rule of law. No doubt, rules-based order is being tested now. Therefore, it is more important than ever that it be preserved and strengthened. It is our fervent hope that Venezuela's expression of disrespect for the court and for international law reflects emotions that often accompany litigation of this kind. We hope that after the passions recede and responsible government officials reflect, they will conclude, as we have done, that both states are best served by an end to this long-standing conflict, and that the only way to secure a just and lasting peace and an enduring friendship is by respect for and compliance with the court's final judgment, whatever it may be. Thank you very much.